Hey, Patrick Mindoro here, co-founder at Visa Franchise. Excited to have on Matt Galati, principal of the Galati Law Firm. We've worked together, I don't know, over the last 6 or 7 years on
I
multiple
lost
cases,
track at this point.
mostly on the E2 side. And, and today it's a little different topic, but very relevant, especially for those people that have been having issues getting their visas, are just in holding patterns. It's been months, it's been years, and we're going to explore a few different ways that you can expedite the process and potentially through litigation. So, Matt, again, thanks for joining.
Hey, it's my pleasure. Big fan of yours. Glad to finally make it on.
No, likewise. So tell me, when does it make sense for someone to start considering options and being a little more aggressive with USCIS or the State Department?
Yeah, I think it really depends on the visa type. So if you look at something like EB5, I think something to consider the day after you file your case almost, because that program has been dealing with all kinds of dysfunction, unfortunately. Um, if you're looking at the visa process, I think it depends on the visa, whether it's a non-immigrant or temporary visa or the green card. If you've had your interview, whether you're placed into something called administrative processing, or if you can't be scheduled for an interview, there's a separate analysis there. As far as the other kind of petitions with USCIS, most of the non-immigrant categories have premium processing now, and that's going to be cheaper than litigation for sure, $2,500, which is expensive, but you're guaranteed an adjudication in 15 days. So a lot of people choose that. It's really just kind of focusing on adding the pressure to the consulates and categories like EB5s that don't have premium processing.
And then walk me through. Are you mostly doing it at the USAS level, so within the U.S., or is it at the consulate level when they're going into processing and they already have their I whatever form, I-130 or 526 approved, and then they're going in for the consulate interview?
Yeah, we've done a little bit of everything, right? So I think most of the dysfunction over the past couple years between having an administration that preceded this one that purposely slowed down immigration benefits, the current administration, I'm going to be equally politically offensive here. The current administration, which has been a little more apathetic about fixing those problems than we expected, and COVID as well, kind of like the perfect storm of delays for immigrants, both on the visa side and the petition side, as you alluded to. We tend to skew a little more USCIS just because of the nature of our practice. I do have many colleagues that only sue the State Department. We sued the State Department this morning, for example, based on a delay involving a doctor getting a visitor visa so he could come to the US and visit his wife. So it is really just kind of dependent, and the analysis on who you're suing differs a little bit, but the fundamentals are pretty much the same.
So traditionally at Visa Franchise, we've had a lot of E2 Visa investors. And especially over the pandemic, a lot of them were super frustrated because it was a year, 2 years. They've already invested in the franchise or they're in the process of investing in the franchise. It does seem like it's gotten a lot better where our clients are getting consulate interviews in a month, 2 months, 6 months stop. But what options when should an E2 Visa investor start really like thinking about their options and evaluating different strategies to move their family to the U.S. faster?
Yeah, obviously, if there's a strategy to come to the U.S. faster, you might want to consider that rather than suing. As far as the E2 goes, it is so consulate specific, right? Because you're going to have a very different processing time in Madrid than you will in Toronto, than you will in Rio de Janeiro, right? Um, there are various strategies you can use. I don't want to use the word forum shop because that has kind of a pejorative term, but it is possible, and the State Department said this at the last AILA National Conference, to move your case from a post that's slow to perhaps one that's faster. Now, that's obviously up to the discretion of the consulate. If I'm I'm a national of country A and I want to apply in my home country, but country B's line shorter. I still need a visa to get to country B, right? I can't necessarily just walk right in. I think that from the outset, when you're working with your attorneys, you want to have a general idea of how long a process is going to take. I, at times, especially these past couple of years, have had to answer truthfully, which is I just don't know. Like it could be a year, it could be longer, it could be significantly shorter. And I think that's true for some visa types, especially EB5. E2s, on the other hand, are a lot more predictable for most posts. So most posts will have an email address that lets you email and say, hey, when are you interviewing people, about how long is it going to take, questions like that. And historically, they are responsive. Historically, they will answer you and give you an idea. Maybe not set in stone, but at least your expectations can be set up accordingly.
So what are some expedition strategies? Like we've had clients where it's super critical, the business is already open and they've made the plea and they were able to move faster. Are there different ways that people can really expedite the process and get to the US sooner, but instead of like going to the next step, which would be litigation?
I think it's smart to try and expedite before you litigate, at least in the visa context, because that's relatively straightforward. USCIS is its own thing, right? But at least the State Department has a relatively straightforward way of doing an expedite, whether you're going for the immigrant visa or the non-immigrant visa. So I'll give you an example. We represented a company that really needed a trainee to come in, and she was from Sweden. And the wait times to get a visa appointment in Sweden were incredibly long, like 6 months or something crazy like that. We asked for an expedite and they said no for whatever reason. So she's Swedish, so she had an EU passport. She hopped on an airplane, went to Germany, and she went to Berlin. We tried the same exact thing, and she got an appointment 3 days later. It's some
Days versus 6 months.
Yeah, exactly, right? So there's some creativity to the process. And again, that works for her because she was Swedish. If she were to be Vietnamese, she can't just hop on an airplane and go to Germany, right? That's not.
And I know we had a mutual client that I think he had a couple of different passports and you really went to bat, like just checking all possible consulates and US embassies for him to apply for the E2 visa.
Yeah. It requires a little bit of finesse in that regard, at least in the non-immigrant route. Immigrant route's a lot more difficult. Like if you have an approved petition and you're waiting for a visa interview, I think that it's much more difficult to move consulates unless you live in the other location or you have the passport. So for example, with the EB5 route, Abu Dhabi, for whatever reason, has been incredibly slow. We've been able to move people that happen to be Indian from Abu Dhabi back to Mumbai and get processed that way faster than suing.
And what are we talking about? How many months or even years?
Abu Dhabi hasn't processed a single case of mine yet since EB5 came back. So that was what, March 2022, and here we are, July 2023, and I don't have a single case through. It's terrible. Huh. Those are like a case I would gladly sue on, right? Because we can talk about lawsuits in a minute, but that doesn't seem like the consulate's proceeding in good faith.
And these are the type of people you would think the U.S. would want to come in and start spending money, taxes, spending, generating the economy. I mean, these are that spend $800K plus to get a visa. Imagine what else they're going to spend money on once they're here.
For sure. I don't know if it's necessarily a priority problem, a capacity problem, or an apathy problem. I've been doing this for 13 years. I'm getting a little jaded, so I'm starting to lean towards option 3, apathy. And so that's why I think I've been a little more aggressive than a lot of my colleagues in pushing the litigation option.
And what's your thesis on just like why the EB5 visa category takes so long, where you have people doing the EB2 and IW getting their premium processing petition approved in like less than 15 days. For me, like a outside, a non-lawyer, it seems like it's also a pretty complicated petition. Like, why is the EB5, why does the EB5 taking 50 months where you have kind of complicated petitions that just take 15 days?
It's not taking 50 months. They published that. It's not at all true. I think right now the EB5 line, there's no line, but if we were to pretend there is one, the adjudications right now, for the most part, are happening in summer 2019, right?
Okay.
So July, August timeframe is what we.
And you see the real data because you're doing serious volume on when clients applied and when they're getting the form approved.
That's half of the equation. We do a lot of litigation for people whose cases are older than that. So we've filed lawsuits for people who filed their EB5 petitions in 2017, 2018. When you sue the government, they oftentimes put up a defense. And at least in EB5 context, their defense has been visa availability approach. If visa available, we'll put you in the queue for assignment. And then we'll get to your case in a strict order. I'm counsel to a bunch of lawsuits, some of which we've gotten discovery. I can't really talk about that as of today, July 20th. Maybe this is an article later to be written or something like that. But the data is showing that there really is no first in, first out line. I think that at the end of the day, and obviously, something that's subject to litigation I don't want to talk about in too much detail, but at the end of the day, at least with the EB5 route, the government has not been consistent. I think that if we had consistency, even if it took longer than the time that we thought it would, we'd have a much. I don't think people would be as mad, right? If things were a lot more consistent. But I get a lot of phone calls that are, my friend John filed a week after I did, and he's had his green card for a year, and I'm here sitting in Toronto waiting for them to get to my petition, and there's not a lot of good explanations most of the time.
And on the EB5 side, do you see a difference on a country by country basis, or is it like investment by investment? Like certain regional centers, it seems to get approved faster. Direct investment, maybe slower or faster.
So there was one regional center in particular that was advertising that they had an expedite, and all of their cases were getting approved in 3 months ish. I think that was a bit of an anomaly. But for the most part, it does not seem to matter if you're in a, for lack of a better term, normal project or a project that has been reviewed. Direct EB5, which I know you've been involved with, that's its own animal. And it's not really clear when those cases get assigned and adjudicated. Also, I don't think the data is as good because there's just so many more regional center cases. We're talking upwards of 95% of the entire EB5 share is regional center cases, right? So in that regard, I don't know, EB5 is its own thing. And it's always changing too. So when we file litigation cases, when the government defends, sometimes they'll put out affidavits, and sometimes the affidavits don't quite match the facts so that we objectively know. 2 days ago, the EB5 unit announced that they're redoing their assignment policies to allow for adjudications by project, by regional center. I thought they were doing that this entire time. Right. It does not really make sense, and I think their announcement gives more questions than answers, unfortunately.
And I imagine for you, years back, 10 years back, there were a lot more folks that were just going right to EB5 or right to some EB2 category, EB1. But
my record is 23 days for a 526. 23 days. That was in 2012, so that's ancient history.
But now I guess
term, right? That's a long time ago.
The non-immigrant categories are all that much more important, and like your craft as an attorney, kind of navigating. Okay, you're going to start first with this, and then we're going to switch to this category.
Right.
I imagine there's a lot more matchmaking, I guess, in terms of just all the different visa options available.
Yeah, for sure. I mean, we've had clients, especially before the advent of concurrent filing, we've had clients do E's and then EB5 or EB5 and then E's, or else. Those are generally that. Most clients that would qualify for like an O visa, which is for extraordinary ability, we were talking about that in the green room before we jumped on. Most of them will go for a different visa and not go for EB-5, but that would work as well, right? So I think that people generally want to get to the US and start their lives and have some sort of degree of stability, especially people with children, right? Most of my clients that are adults are doing EB-5 because they want their kids to go to better schools than wherever they're located, right? That's the primary motivator. And so concurrent filing has been a total game changer in that regard. But still, at the end of the day, you have a chicken and egg problem. How do I get to the United States? And how do I get to the United States in a category where I can apply for the green card right away?
And compared to other countries, like the F1 student visa, it's not dual intent.
Right.
Like a lot of places you can study and there's a clear path to work and get a permanent
Yeah,
residence.
Canada, for example, right?
Yeah.
I mean,
If you're a student, there's a clear way. You're going to be
it
able to
makes no sense. Like, why would we put so much of our resources to educate foreign students and then not welcome them after? And I mean, we can getting way off topic here. We talk about the H1B visa and how dysfunctional it's been this past year, but you're right. I mean, it makes very little sense.
H1B, what was the percentage was extremely low, right? Like
I have one
12%.
client that like filed 20 and they got one, and we were just besides ourselves on that.
Our companies filed in the past, but then we stopped just because it was like building false hope for the applicant that they were going to work with us and continue on with us, and it wasn't a good. It's not good for anyone. It's sad because that's generally the big option for students stateside.
Well, yeah, not just that, but I mean, you as an American employer, like you don't have offices all over the world where you can avail yourselves of L's. You're an American yourself, so you can't do an E and bring in foreign employees, right? So it's simply that we kneecap American companies in this regard by making the H-1B so unpredictable.
Yeah, it's an interesting topic because you have a lot of E2 visa companies like the large Japanese banks, German
Yeah,
manufacturers, French companies, and the consumer goods space that they have hundreds of E2 managers they're bringing in. And
yeah, for sure. Yeah, I mean and it makes it harder for American companies to get that level of global talent unless they have operations abroad.
well, Matt, we have a few questions I'd like to go through if that's okay. Some of them are some are on topic, some are a little off, but
That's
if
okay.
you're
We went off topic. I don't mind going off topic.
so Andrea is asking, what can I do after a visa rejection to improve future applications?
Ooh, that's a tough one. I think it depends on the reason for rejection, right? So, like, if you murdered someone, I don't think there's anything you can do. It's important to sit down with an immigration attorney and kind of recap the interview. I think a lot of our clients too come to us months after the interview and memories fade. Usually when you get a visa rejection, especially if it's something called a 214B rejection, which is basically kind of a catch-all category, you're not going to use your visa in the way that we think you're going to use it, then it could be any reason whatsoever. So sit down with an attorney and kind of go over what happened. It could be something as silly as you didn't bring the right forms or you let off the wrong way or something like that. And usually with some good, I don't want to say coaching, that's not the right word, but some good advice and role play and practice, you can get it done, usually, for most of our clients at least.
If someone's denied for an immigrant visa, say the EB-5 or the EB-2 NAW, will it make it harder to get then a non-immigrant visa in the future?
I think almost always that would be the case because usually those denials are going to be based on a category of inadmissibility, right? So if I've been denied an EB-5 visa because I committed grand larceny, right? I can't imagine getting a visitor visa after that. Now there's a blanket waiver that's available to the non-immigrant visa categories, not this significantly more powerful 212D3 waiver, significantly more powerful and easier to get than the immigrant visa waivers. But at the end of the day, it's definitely not something you want on your resume. Now, that being said, there are some categories where you're not going to get an immigrant visa that are completely inapplicable. to non-immigrant categories. I'll give you an example is Communist Party membership, right? So Communist Party membership can be a big problem for a green card, but plenty of Communist Party members send their kids to schools in the United States as students.
And we have a question from Nico. Hey, how can one stay updated in changes to immigration policies and procedures?
Nico, I wish I knew the answer to that. That's a challenge for me too. It's extremely difficult. For the most part, I mean, obviously, I am an immigration lawyer. I'm a member of the American Immigration Lawyers Association, or AILA. They do the best job of anybody of keeping us up to date and competent. But for a lay person, you can't just walk into a lawyers organization. I kind of going outside the box here. I think Twitter would actually be one of the best. I mean, people have been leaving Twitter left and right. Whatever your opinion on Elon Musk and his takeover is, it's still where a lot of really robust immigration discussion pop out.
I've seen you're pretty active. You have a lot of followers.
Yeah, I make a character of myself, I think, on Twitter. My Twitter photo profile picture is me in an American flag suit. So pretty serious job. Don't take myself too seriously. But at the end of the day, you get a lot of information from trusted people that have trusted reputations in the industry, people that have been doing immigration law, some of them longer than I've been living. And obviously not everything on Twitter is going to be accurate or complete, certainly not legal advice, but the immigration Twitter community, I think, is actually pretty good at communicating what's going on and doing it in ways that a lay person can understand. Even if they're like me and act like professional wrestlers on Twitter, that's just my personal style. But if I was a lay person, I would look there.
I've been seeing a lot on Twitter and YouTube, kind of like interim strategies for H1B holders to stay in the U.S.
Yeah, or go to Canada, right? That's the other thing too.
That's a big thing.
Canada declared war on the U.S. immigration system a couple weeks ago. But, yeah.
Hopefully that pushes members of our Congress and Senate to act. But one thing that's kept coming up, and I've been asked about, is CPT. People that they have a job in the U.S., maybe they're on their OPT status or whatever status, and then they enroll in a graduate program. And from what I understand, they can work right away sometimes, or they can work after a year. Do you have any experience?
Yeah, the master's program, you could start. A bachelor's, you do need to wait. A master's program, you could start right away. CPT is controlled by the school. So some institutions will not grant it right away. Some institutions, I guess, won't grant it under any circumstances. There are some schools out there that, I don't want to say advertise, I think that's the wrong word, but are well known for giving CPT in the first graduate semester. And in the past, I've seen employees of clients go that route, and so that at least they can work part-time for the employer that submitted the H1B in this era lottery pick, and then they were not picked, right? So it is a very incomplete solution to that problem, but it's better than nothing, right?
And are there any limits? Because I've seen on some people's CVs, like they just keep getting masters, and it seems, I don't know if they're on OPT or CPT, but it seems like a common thing, especially for those born in India, where now, besides the EB-5, all the green card employment categories are backlogged 10 to 50 plus years.
Yeah, it is unfortunately extremely difficult to immigrate, meaning green card, United States, if you were born in India, right? Your only way out of that at this juncture is to do EB-5, which of course has its own challenges, we alluded to, or marry someone that was not born in India, right? I mean, that's kind of it. So that has been incredibly difficult. there are limitations to CPT. A school will have its limitations in the regulations, full-time versus part-time, using full-time CPT, taking away from OPT. So I think it's important for someone to sit down with an attorney, designated school official, DSO, to kind of map that out.
And then we have a question from Tomas Jameson. Could you talk about overlooked documents that impact visa processing times?
I'm not sure what overlooked documents means in this context. Are we talking about not bringing
maybe how to avoid a request for further evidence, or the state and asking, basically for more documents?
Yeah, sure. So obviously working with an attorney who has experience is going to more often than not increase your chances of getting a case approved and avoiding what Patrick alluded to, a request for evidence. It really depends on the visa application. So for example, if you were doing an E2 visa, right, you have to prove that the company that you invested in has your nationality. So if I create a limited liability company, I need to show that the company is, and let's pretend I'm Italian. I need to show the company is at least 50% owned by Italian nationals. And I would do that through something called an operating agreement. If I don't include my operating agreement in my E2 visa application or my E2 petition with USCIS, yeah, they're going to come back and ask for something that shows the ownership for sure. It's really a case-by-case thing. If you're a student, you don't have your CVIS bill paid or your I-20 issued, you're not getting the visa without that, right? So.
And Matt, we've been in an awkward situation, of course, never with your clients, but where there's been a denial and the client's coming to us for like feedback on whether they stay with that attorney or switch attorneys.
Yeah.
Putting yourself in the immigrant's position, or even that E2 visa position, what do you do? When do you like work together with the team you already have versus potentially go down another path?
I can't say I've never not had a denial, right? So I've, got some blemishes in my own skin, but I would think that that's not necessarily due to lack of effective representation. Immigration is very difficult, right? That being said, immigration lawyers are people, and there's different levels of skill and expertise. And sometimes lawyers take on cases that they either don't have the time to do or the capacity / experience to do, right? And so I think that the first and most important thing to remember, at least with an attorney-client relationship, is that the client has almost all of the power in that relationship. So if you don't like your lawyer because he has a stupid face, you can fire your lawyer. Now, the opposite isn't true, right? I can't just, in most circumstances, right, you can sever a relationship with a client for almost every reason, but you can't prejudice the client, right? So I think that fit is very important. Personality is important. Keeping expectations is important. If you have your case denied and you go to a different lawyer for a second opinion on what happened, which is, sometimes a strategy that you'd want to consider, and they say, and I've had this happen to me too, right? Like I've had clients come to me and say, oh, my case was denied. Can you help me refile? And I'll sit down and look at it and be like, hey, look, honestly, lawyer Smith, who had your case before, approached this exactly like how I would approach it. We can do this again, and maybe there'll be a different result because we get a different adjudicator. But at the end of the day, I don't have much to fault here. Other times people come to me and it's like, well, look, this is very clearly lawyer Jones's first time, right? So I think getting a second opinion, if you have any suspicion that the lawyer didn't do what was necessary to get your case approved, I think that's a smart idea.
Thanks for that.
Even if you end up staying with your team.
Yeah. Any concluding thoughts in terms of folks that maybe have already applied for a visa and they're just kind of in limbo and they're
So we didn't actually talk a whole lot about litigation, but let me kind of recap a little bit about that. The idea of suing a government is extremely foreign, for pun intended, for most people that are not in the United States. I have a good friend in the industry who says that suing the American government is the most American thing you can do. I don't know if I agree with that, but it gives me a chuckle every time he says it. The number one question I get when I'm talking with someone about lawsuits is, will the government retaliate against me? By suing it, are they just going to deny me? Are they going to
blacklisted? Your children get blacklisted.
And having done this essentially full time since the last EB-5 visa lapse, right? It's not the one in 2021, the one before that, being involved in the mandamus litigation. I've just never seen it once, not once.
That's good.
Now, you might not want to file a suit to speed your case up if the result is really bad or if there's something about you that's unresolved. So, for example, we did file a lawsuit for someone who had pending criminal charges against him, and it would have been in his interest to wait until he had resolved this with his criminal attorney rather than try to force a result when we filed. I didn't know that at the time, and I would have told him that.
It wasn't disclosed to you.
You don't assume that, the FBI is coming to your client's kitchen table and asking a bunch of questions, right? You didn't disclose it. It's not guaranteed, right? Premium processing is more or less guaranteed. You pay $2,500, you're going to get a decision within 15 days. Litigation is adversarial. Litigation, you're paying a private attorney to go up against the assistant United States attorneys. We went to law schools with those guys. They were usually at or near the top of the class. They're smart. They know what they're doing. But so do we, right? And so I think that if you've tried other options and the wait just seems unbearable, or you've seen a lot of success through litigation, which is especially true in EB-5, then I think it makes sense to call an attorney that does immigration litigation, specifically delay litigation, have a conversation, sit down and say, okay, I filed on X date. It doesn't seem like they're getting to my case. Are you seeing cases being approved that filed after me? What do you think is going on here? And the other thing too is that the actual litigation parts of immigration litigation are kind of boring, right? Like, we don't have sexy trials with juries where someone stands up in the courtroom and is like, oh yes, it's him that delayed the adjudication of this petition. That doesn't happen, right? Most of it's on paper. There are hearings, right, that you can go watch them sometimes, but most of it's on paper and not terribly exciting to a layperson. Nerds like me it is, but to a layperson it's not. And so one of the most effective things that you get by filing a lawsuit is that for the first time, the government will assign someone whose job it is to make the lawsuit go away. And that's the United States attorney, right? And sometimes they make the lawsuit go away by calling up me and saying, hey, what can we do to make this lawsuit go away? Sometimes they make the lawsuit go away by calling their client saying, this is ridiculous, approve or deny the case now. And sometimes they make the lawsuit go away by trying to fight the lawsuit, fight me, fight my clients, right? But don't underestimate the idea that by filing the lawsuit, you make this someone else's problem, right? And I think that having someone else have to take ownership of the problem you're facing, even if they don't agree that you're entitled to the relief that you want, is in and of itself incredibly powerful.
Yeah, I mean, you're inevitably going to go to the top of.
Think about it this way: an adjudication for an EAD, employment authorization document, takes 6 minutes according to the regulations. 6 minutes, that's it. So if they wanted to automate this through AI, I'm sure they could. It's 6 minutes. It's not terribly discretionary. You fill out the form right, you attach your photos, you pay the fee. There it is, right? Does it really make sense for assistant United States attorney who has to deal with people that fell in post offices and tore their ACLs and suing for millions of dollars. Does it really make sense for them to divert their attention from that to your 6-minute EAD, right? I mean, come on. So I think that is one of the more underlooked process of litigation is, even though it's adversarial, working amicably with the other side to get the result we want.
One conversation I've been having a lot more is with H1B holders, especially those who were born in India, about doing a EB-5 direct. Okay. They're largely looking at the direct because they're not multimillionaires. They're scrapping together 800K and they have not 850K in their name or 900K in their name.
Yeah.
And they really need the money to work. And some of them are looking to go more in an entrepreneurial space, but I don't think many of them know that what you were saying, doing a adjustment of status, concurrent filing. I think that'd be one topic to kind of discuss a little bit today.
Okay, sure. Yeah, why not? I mean, H1Bs are great for concurrent filing. It's a dual intent visa. You'll get a work permit usually 90-ish days after you do the filing. You need to maintain your status for the most part up until the time of the concurrent filing. So this is not by any means legal advice, but we have had clients decide after that they filed for their green cards to no longer work for their employers, use their employment authorization documents and do what they want with them, right? You don't have to be necessarily wedded, again, not legal advice, not necessarily wedded to your employer for an indefinite period of time if you can get that adjustment in. It's no secret that India has completely replaced China as the hegemon in EB-5 industry, at least certainly until the set-aside categories were set up. And unfortunately, with wait times in the EB-2 categories, some calculating them to be 150 years, which is twice as long as modern Republic of India has existed, there's really no other option. Not everybody's going to be Nobel Prize caliber talents in their field. And so you're right. A lot of people are saving up and saying, okay, I'm going to work with Patrick and I'm going to run a $800,000 equity business and get my green card that way.
And the EAD,
sorry.
Oh, good.
I was told to silence the phone and I didn't.
The employment authorization doc, how long is that taking and when does it make sense? Because imagine some of these folks are making $250,000, 300K, 400K,
yeah.
And for them, it's very worthwhile to be able to work where they would like to work.
Yeah.
How long does it make sense to litigate on that?
Oh, to litigate on that. I think you're asking me to do that, and I was going to give you the usual lawyer punt question. Historically, they've taken 90 days. So remember when you file a lawsuit too, for the most part, after you file a lawsuit, you have to do service on the government, which isn't like in the movies. Like I don't jump out and behind bushes and surprise like the head of USCIS with the lawsuits. It's nowhere near as fun. We send it through the mail, right? That's what the rules say, and that's what we do. So we don't get to hire people to do fun stuff like that. But after that service is made, the government by law is required to respond to the complaint within 60 days. And of course, there's different things they can do, like I alluded to earlier. So for an EAD, again, every situation is going to be different. Every court that you file in is going to be different, which is a whole other topic we can talk on. But I, for the most part, tell my clients to wait 90 days and then file. And then by the time the government gets around to it, it's been 5 months. Now, okay. Especially because they decoupled advance parole and the employment documents with adjustments at the very least, they're supposed to be moving faster.
Matt, and I appreciate all the questions. I know we went kind of all over the place, but part of it was what people were asking, as well as conversations that I've had recently that are quite pertaining to now. This is July 2023, and folks looking to get their visa fast, and if that means through an expedited process or through a lawsuit. What's the best way for people to get in contact with you, potentially schedule a consultation on their case?
Oh, thanks so much. So if you Google Matt Galati, there's a hockey player with my name, but I think I'm right underneath that. So if you Google Matt Galati Immigration, you'll get to our website, which is just my last name, galati.law, GALATI.LAW. My email address is matt@galati.law, so my name. You can also catch us at info@galati.law. Like you alluded to, also, I'm on Twitter. I get a lot of clients through DMs that enjoy my banter, and other social media types like LinkedIn, for example. Plenty of easy ways to contact me through there.
Perfect. Really appreciate it, Matt.
You got it. Thanks so much for having me. I'd love to come back.